Today I'm meeting with Clark Ward. He's a mediator that's been around for quite a while. He knows what he's doing in the field of mediation, and he's a former attorney as well. Just doesn't practice law now because he's focusing on mediation. We were talking a little bit off camera. And today's, the purpose of this video, we want to give the information out there to people that haven't been to mediation. Maybe it's their first time coming to mediation. I went through a divorce, but I'm going to ask questions as if I didn't, so that we can try to cover all of the questions and the things that people want to know about mediation. And some of the things that I'd kind of thought about, we've talked about a little bit off camera, is because in Utah it is mandatory, right? You do have to at least attempt mediation.
It is. In any disputed domestic case, it is mandatory that you attempt mediation at least once.
Right.
And oftentimes a judge or a court commissioner will order you to go back a second or even a third time.
If they think that you didn't give it an honest attempt?
Yes.
Okay.
And if they think that there's still a reasonable chance that you might be able to resolve more or all issues by going back.
So it almost sounds like the courts maybe don't want you to take your divorce to court. Is that kind of the feeling?
That's the feeling.
Okay. And that's maybe a good thing, maybe a bad thing?
I think it's a very good thing. I think it's an important thing to learn and to understand, because first of all, my experience is that the parties want to be heard first and foremost.
Sure.
And we all have this misconception of that we have a right to a day in court.
That the courtroom is where you're going to be heard. Wrong.
That's wrong,
Right.
Because the court doesn't have the time.
That's right.
And even if they did have the time, they're already thinking about the next case while they're trying to resolve yours.
Sure.
Let's not make any mistakes about that.
That makes sense.
So in a mediation setting, you have as much time as you want to take.
So most of them are they a half day, a full day? What's kind of the norm?
I would say that they range anywhere between 3 hours and 6 hours.
Okay. So you're either going to do 3 to 4 hours, half day, or maybe a full 8, maybe 6.
Yeah. No, I've been in a mediation myself. It went 11 hours.
Oh, wow.
I've heard of mediations going in 17 hours all through the night.
Wow.
Now, those are rare.
Like labor.
Yeah, those are rare, and I wouldn't advise my client to do that because it's so exhausting to begin with.
At that point, you don't know what you're agreeing to, right?
Well, yes, and everybody is tired, including your own attorney.
Sure.
And if you're going to have an agreement and you're going to sign it, that's fine.
Right.
But if it's a good agreement, it'll feel good the morning after, as well as the day of.
Sure, you won't have a lot of buyer's remorse. I mean, you might have a little because you're not going to get everything you want in a mediation.
That's right. And if you are able to think about it and take a step back from it, you can relax a little bit, and oftentimes you'll think of something that you didn't think of at the time.
Sure.
And the big mistake in mediation that people make is that they want to rush to get some kind of an agreement signed that's binding, and then almost immediately after that they realize, oh my gosh, what have I done?
Okay.
And it might be too late.
So that was one of the things I was going to ask, is kind of what are the do's and don'ts? So go to mediation with at least in mind or in your heart, like the chance, give it a chance. Like, don't go to mediation and think there's no way I'm going to give it a chance, because you're just doing yourself a disservice, right?
Right. They have done a lot of studies about this, and that's why it's mandatory, because the studies have shown that it is more effective to address and try to resolve problems through mediation than it is by simply handing it to the judge and say, here, you try and figure it out.
Because the judge may have no idea what's going on, and not that the judge is clueless or isn't wise. It's just they don't know the situation. They don't have time to get into all the nuts and bolts and get into the weeds of it.
Correct.
Whereas mediation, you have that time.
And the agreements that the parties make between themselves are generally adhered to better than orders that the court mandates on them.
Right, instead of like you're ordered and now it's a chore and you got mommy, the government looking out after Big Brother. Yeah, so that all makes sense. I went through a mediation. I had a pretty horrible experience in mine, but it wasn't the mandatory thing. Mine wasn't horrible because of the people involved. It was just it was just kind of a it was a bad thing from the get, and that's not really part of the video, but I definitely was glad that I at least gave it a shot. I had that clear on my conscience that we tried to resolve it before we went to court. That's invaluable in and of itself, I think.
Yeah.
Because you at least tried before you took it to the court, because like we've been saying, the court probably doesn't want to deal with it, probably can't properly address it, and people have that misconception that I'm going to go in there and tell the judge this and this and that. No, you're not. You're going to have like 2 seconds, and your attorney's going to do most of the talking.
For parties, I'd like to talk about parties and the attorneys representing the parties for just a minute.
Sure.
For the parties, again, we talked about the misconception that you're going to have a day in court and you're going to have unlimited time. That's not true.
Right.
Another misconception is the judge is going to see things just the way that you see them.
Right.
Well, if you have 2 opposing parties,
right,
and the judge believes everything that each party says,
right, he's never going to believe anything because they're going to contradict.
That's right. So he's going to believe some, and he's not going to believe others, and it will surprise you what they think
Where
is
that
important.
falls. Sure.
Yeah.
Sure.
So it becomes very risky.
Sure.
So you think that you can eliminate that risk by being able to present superior evidence to the other side.
Sure.
But you don't know if that's going to be believed, even if it's admitted.
Sure.
And the process of admitting evidence and testimony is fragmented. You can't go on the witness stand and just narrate without interruption. There's objections, and then the court's going to interrupt you, and so you can lose your train of thought very easily.
Sure.
At mediation, you can do that. You can just tell your story the way that you want it to be heard without interruption, because most of the time you and the other side are in separate rooms. Okay? Your attorney can filter that information out.
Kind of going back and forth.
Yes, and the mediator can filter some of that information out and go to the other side.
And the 2 separate rooms helps to take some of the animosity out of the room. You're not sitting in the room staring at somebody that's ruined your life.
Absolutely.
Or that, cheated on you, or whatever's going on. Whatever your problems are, you're not sitting there seething in it.
Most of the time, if not all of the time, everybody feels like their emotional needs were not met in the relationship.
Sure.
And so it's very awkward to sit at the same room and across the table from the person who was denying you an emotional need that you were trying to get. So that's one reason why it's important to go to mediation. For the parties, they can be heard, and they can be heard completely. For the attorney, it's important to go because, one, it's a rehearsal for the trial. He gets to see what kind of a witness his own client might be.
Sure.
He gets to see the information that the other side has.
Sure.
So there's a tremendous information gathering opportunity here that
it's a good way to kind of feel out where it's going to go if it goes to trial or if you have to take it.
And that helps him evaluate the strengths and weaknesses of both parties' sides.
Sure.
And so it's somewhat a rehearsal. The client again gets to be heard. Okay. And so with the mediator, the exchange that goes back and forth with the mediator and the other side, again, it helps the lawyer evaluate the strengths and weaknesses of his own case. So if it does go to trial, he knows what he has to prepare.
Sure.
Okay.
Yeah, that makes sense.
And then I think that there's a catharsis for the client that at least that they've been heard. And if they understand that there's no stress in the mediation that can compare to the stress of being in court on the witness stand.
Sure.
When you're in court, you have one chance and one chance only to tell your story. And as I said, it can be very fragmented and interrupted. But in mediation, you're going to tell your side, listen to the other side, and then you can rebut that other side, and it goes back and forth. So there is a back and forth dialogue that does not exist in the courtroom.
Right, and in the courtroom, you're up there trying to present, your exhibits or whatever, and then somebody, objection, reading the witness, objection.
That's right.
Speculating.
And then you go back and court says, okay, counsel, proceed. And you go, okay, where was I?
It's kind of like a tennis match with attorneys, throwing back and forth words. I've been to some mediations, I've been to some depositions, and I've been to a couple of trials in doing legal work. And Yeah, it's very, like you say, it's more like a tennis match between attorneys throwing words back and forth,
Right.
and you're kind of just barely there, getting a little bit in every now and then.
Well,
So-
think of a basketball game. You have one team, and they just get hot, and they're making every basket that they throw, that they try and make, and the other team is thinking, I got to stop this momentum.
Yeah,
So they call a timeout,
sure.
and it becomes very effective.
Yeah,
The same thing it happens in a courtroom.
sure.
I did this many times at trial.
Yeah,
The other side is on a roll, and
Right.
I got to stop them.
yeah. And you're like, wow.
I got to break this guy's chain of thought.
Sure.
So I'll just say, Your Honor, I object.
Right.
And then the judge says, what's your objection? Oh, I don't know what I have. I had to think of something quick.
Right.
Okay, so you think, well, there's no foundation.
Right.
Okay, he's not laying a proper foundation.
Right.
Something like that. The judge overrules you,
Sure.
but what you've done is that you've broken the guy's chain of thought.
Sure. You still slowed him down from just steamrolling the case.
Right.
Sure.
So you don't have those games, and you don't
Right.
have to worry about that at a mediation.
Sure.
And
And you can take a break.
you
It's
can
much
take
more
a break.
relaxed. You can,
That's right.
like, everybody can go, okay, hey, we've been at this for a couple hours. Let's go get a drink. Let's do whatever.
And you should do that.
Yeah.
You should do that.
Right.
So you start getting emotional. You need to take a time out and just go out and get a breath of fresh air or whatever. Take a half an hour, just recompose yourself.
Sure.
But it really does help the client and the attorney understand the strengths and weaknesses of their case.
Sure.
Okay.
One of the other things that I was wondering about, most people, if they don't understand kind of how the mediation takes place, maybe we could go through kind of a, point A to point B.
Sure.
Do you have to show up in a suit? Do you have to do X, Y, and Z? Do you have to keep everything a secret? This is your one chance, like you say, to kind of get to spill the beans, tell the story, get it over with, and find a resolution.
Yeah.
So, one of the other questions, I'll kind of tie it into this, is, if I finally have a breakthrough, and I'm just feeling real, I'm just confessing everything I did wrong in my marriage,
Right.
why we're here today, because maybe I don't want to get divorced, but
Yeah.
it's happening, and I got to come to terms.
Yeah.
And so I divulge maybe a little too much. If I talk to you and say, I've got a drinking problem, or I've got a gambling problem, or whatever, at what point do you as a mediator have to, by law, say, okay, I have to report this now?
Well, the only thing that the mediator is mandated to do by statute is report child abuse,
Okay.
elder abuse, and I believe
So if I'm not out
computer fraud.
if I'm not out there kicking puppies and stealing stuff and doing horrible things that are harming other people, but maybe I was, just kind of sloppy in how I said, that I cared about my wife, or just some of the dumb things that maybe led up to the divorce. That
Well,
wouldn't be,
that's where a good mediator will keep the parties on topic.
okay. So you're not rambling off about.
So that you're not rambling off. And because of course, if they're willing to pay for your time, I guess you can sit there and listen to them tell you their whole life story.
Sure.
But I think that the best way to prepare for mediation is to, if you're represented by an attorney, is to go over all of the issues that could go to trial
Okay.
and talk about those issues.
So go before mediation, kind of go over what you're going to bring up, what are the major issues, what are things you don't really care about, kind of have things figured out before you get there, so you're not wasting all your time doing
That's
that when
right.
you get there.
That's right.
Okay.
And I always invite the attorneys to give me an outline of what the issues are, so
Sure.
I can be thinking about it a little bit in advance.
Sure.
Okay, if there's a
That's a good
custody issue, then I'm going to want to ask certain questions. Well, how old are the kids, and what has been the arrangement? Have you been separated for a long time? Do any of the kids have a specific interest or a specific hobby that one parent is better equipped to handle than the
Or
other?
maybe a specific need even.
Yeah. That way the attorney isn't caught off guard
Sure.
and just has to be off the cuff.
Sure.
I would rather be prepared just like I would like them to be prepared.
So one of the things that kind of always comes up, and again, this is me pulling from reference from like a client asking either me or, when they go to mediation. I know the kind of common things that come up.
Yeah.
And one of them is, well, how much power does the mediator have? Some of them are under the the impression that the mediator is like kind of like the judge, like
Yeah.
he's the one overseeing everything,
Right.
and telling the other attorneys what can and can't happen. And
And
you're more of a neutral party. You're there to kind of
have-
be the peacekeeper.
I have to be a neutral
Right.
party.
Yeah.
I cannot take sides.
Sure.
Now, there have been plenty of instances where a mediator has taken sides.
Okay.
And, that's unfortunate. But
Right.
you as you track through a mediation, it's interesting. You'll start to vacillate from one side to the other at times.
Mm-hmm.
But you have no power. You
Okay.
do not issue orders.
Okay.
You can give your opinions. You cannot give legal advice.
Okay.
If someone
So you're
says,
not there in a legal capacity. You're more like a
right.
I don't want to say arbitrator.
Well, an arbitrator does it's a fine line between the two.
Okay.
But you're a facilitator mainly. You're trying to facilitate a discussion on the issues.
Your goal is to see if we can solve things before we got to go to court.
That's right.
Okay.
And you can give them some suggestions, some options to perhaps help them
Okay.
think about some solutions that they may not have thought of.
Okay.
There's a certain amount of salesmanship, I guess, but really you're a neutral party and you want to listen to both sides. If they say, what should I do? That's when you have to say, I cannot give you legal advice.
Right.
I would encourage you to get an attorney and get legal advice from your attorney.
If they don't have one.
If you don't have
Most
one.
people go to a mediation with an attorney, right?
They do, and they
So
should.
you're usually looking at like 5 to 6 people minimal, right?
Right. They do.
You got
and-
an attorney, the client, attorney-client, mediator. At
yes,
least every time.
they do, and they should.
Okay.
And they should meet with the attorney in advance.
And then that brings up a question. If you don't have an attorney, can you just bring a friend that helps you decide things? Maybe your mom or...
Well, the law allows you to bring one support person into
So-
the mediation session with you. Now, that one person can be your attorney,
Mm-hmm.
or it can be somebody else, but it cannot be both
Okay.
unless the other party consents.
Okay.
So, for example, let's say that you come into mediation and you're bringing your brother with
Okay. Okay.
you, and but you have your attorney as well.
Okay.
The other side says, "Oh, that brother, he's the one that's behind this whole thing." Or let's just say it's your mother. I've
Okay.
seen that more often than not. You see the mother with their daughter, or their father with their son, or the father with their daughter, and oftentimes it's the parents of the parties that are fighting harder than the parties
Right.
are.
Of course.
So at that point, you have to get the consent of the other party for them to remain in the mediation.
Sure.
And if they
So
give
you
that,
could essentially go with an attorney and like a family member.
Yes.
If the other parties agreed, and they'd probably want to do the same.
that's right.
They'd probably say, "Well, I'm bringing my sister then."
And then even if they do consent,
Mm-hmm.
you have to be mindful as a mediator that they cannot take over the mediation.
Right.
They cannot hijack the process. So
Because then you're not going to get anything done. You're just
that's
gonna-
right.
you're
This
gonna
this is the,
spiral off on some other fight.
that's right.
Right. That makes sense. All right. Well, I'm wondering if you've got any like success stories or anything you wanted to share, because I mean, I'm really impressed with. I know that you've been doing it a long time, so you obviously are a good pool of wisdom, and you've seen the things that you shouldn't do. You've seen some of the. You probably have some good stories, either without naming names, whether good or bad, and it'd be kind of interesting to hear one of each if you had one.
I've tried to forget most of them, and honestly, I do. Once it's over, I pretty much forget about them.
Yeah.
So people can know that what they tell me in confidence is not going to be retained.
Right.
I don't keep a journal of.
You're not going to bump into him at the grocery store and then go over a laundry list.
Well, I
Grill
might
them.
I might see a familiar face,
Sure.
but that's about it.
Yeah.
Well, I can tell you some things that over the years that, now that I'm thinking about it, I remember as really good things that I've seen.
Sure.
First of all, what I've learned is to be prepared in advance.
Sure.
And I remember going into a mediation on more than one occasion, and the other side handed me a proposed agreement.
Okay.
Well, what that tells me is that they've already met and discussed the issues in advance, and they have a template that we can work off of.
Sure. Sure.
So I adopted that, and so when I was practicing, I would have a proposal hand delivered to them on the other side, and
Okay.
they would review it, and we would work off of that. We
Sure.
can agree with this, not that. But we
Instead
would
of just
work
like,
off
well,
of
here we are, where do we start?
it. Right.
At least you have a start.
So have a proposal in mind on every issue,
Okay.
a reasonable proposal, knowing that they're going to have their side of the story too.
And is it good to kind of show your cards? Like, I mean, let's say, the one thing holding me up from getting a divorce is child custody. And everything else I don't really care about. I don't care who gets what car. I don't care who takes what couch. I just want access to my kid, and that's kind of what most people want. The thing that really hangs up is custody usually.
Yes. I think that it's good practice to commit to writing everything that you can agree to first.
Sure.
It's less stressful.
Plus, you feel like you're getting somewhere.
You're getting somewhere. It builds momentum into
That might
the
have helped in
discussion.
mine. I didn't go with any type of proposal. We just sat down. It was a disaster.
Yeah.
So I think if I might have done some of those things where I at least had like, look, here's all the things on the table. Here's what I care about. Here's what doesn't really matter that we can agree on.
The more that you're agreeing on the little things, it builds momentum that will help you address the bigger
Maybe you
things.
regain some trust and you could get it over with and get out of there and
Yeah.
be about your life.
Right.
Yeah.
So that was one thing. Another thing that I thought was really good, I remember a couple of mediators, they will just say right off the bat, what is it that you want?
Right. Kind of like the Notebook scene. What do
Yeah.
you want? What do you want?
Yeah. So it helps you understand what their expectations are.
Okay.
Well, I want 80% of his income. I want him to be ordered to drop to his knees and beg for forgiveness.
Sure. Okay.
So
These aren't unreasonable at all.
yeah.
Sure.
So what is it that you want? Okay, you keep a note of that, and then you just work down those things.
Right. For me, all I wanted was equal access to my kid and everything else.
Yeah.
I mean, sure, did I want the house? Yeah, but I mean, I understood, maybe to my own detriment, that if I didn't get the house, he's got a roof over his head.
Yeah.
And so I was fine with that. I was like, well, that kind of stinks. I'm not getting any equity. My house wasn't worth a lot. It was a mobile home. It wasn't even really a true house. And so it was just like, well, if I don't get raked over the coals on the child support, which it was rough doing child support, but I didn't have alimony because my marriage wasn't long enough for alimony, so it could have been way worse. But
well, mediation is a process that's part of a larger process of the entire case, and so if you have to have the parties, and I let them know right off the bat that it is a process. We're going to be working through some things,
sure,
and part of the process is getting them to, first of all, relax.
sure,
Secondly, is to be open-minded that there might be an option here that I hadn't thought of.
sure.
And third, that the other side has
I
their
might be
story to
blinded
tell.
by my anger about this situation.
Exactly.
A third party could go, hey, what if, right down the middle, you do this weekend, you do that weekend, maybe after work, I hadn't thought about after I'm off work. And because sometimes I think that's one of the things that's bad when people do rely on the courts to intervene.
Yeah.
I think so many relationships and divorces and people trying to move on and be like a step parent, or there's a lot that comes into the mix. I'm a step parent, so I know kind of how that goes.
Yeah.
But when you're still trying to, the guideline and the statute, yes, I'm not flouting any court order by saying this, but you don't have to live by those schedules.
That's right.
It's a guide. It's there for you if you can't agree, not the other way around, which is, well, we can't because it says we can't. No, you can. If you want to give more time, give more time.
Exactly.
And that's the way you should live, because then again, you're running your life. The court isn't.
And that's the way that parents need to look at sharing time with their kids.
Yeah.
They are guidelines. It is not one size fits all.
Right.
The legislature, of course, had to come up with something if the parties cannot agree. But
And that's
really,
not to say take your decree and throw it out the window. You're supposed to follow the stuff in there.
Yeah.
But when it comes to parent times, what I'm talking about, if there's a chance or an opportunity where somebody, let's say I was working, so my schedule was way more rigid. Well, now I'm not working, and I've got a little bit saved up. We're okay, child support, everything's still getting paid, everybody's eating, everybody's okay.
Yeah.
But we've got kind of like a 3 to 6 month window where I know I'm going to get new income. Let's do more time. I'm not working. Let's.
Yeah.
And I see it all the time where people are like, well, the decree says this, and you're getting way more than you should already. And it's like, don't do that to your, because you're only doing yourself a disservice. Sure, you might feel good because you're getting the other parent, but really what you're doing is you're saying, my kid isn't important enough for me to look past my own BS and just say, even though he's asking and I don't like him, and he doesn't like me, and we went our own separate ways, we have this common bond forever, probably when you have a kid. It's never going to change. Even when they're 18, there's less to argue about when they're 18 because they can make up their own mind. But you're not getting rid of that ex if you have a kid with them. You got to treat it like a business and move forward and think about the child, not yourself. And it's hard for some people when they're in the thick of it and they're still angry and their emotions are clouding their judgment.
I remember a former commissioner up in Weber County.
Okay.
At a pretrial conference. It was a custody issue and a visitation issue. And he addressed the parties. He said, look, do you want, when your kids grow up, and do you want to be on separate sides of the salon when they get married? They're at a reception, and
Sure.
you have father sides on one end of the room and the mother's on the other side of the room, and they're sneering at each other.
Sure.
He says, is that how you want to honor your children's marriage?
Right.
He says, you've got to learn to put aside your emotions
Yeah.
and promote the interests
And
of
meet
your
and
kids.
give those people that day and put your own issues aside.
Yeah.
Yeah.
So, unfortunately, what seems to underscore all of these disputes is just the emotion and the anger or the frustration that a party feels
Sure.
because the marriage has been shattered.
And by us talking about that, we're not trying to belittle anybody.
No.
Because I went through it. I was the rug was pulled right out from under me, financially, emotionally, psychologically. I was not prepared. I didn't want it to happen. I thought I was with the person I was going to be with forever. I didn't want to break up my family. I mean, I was hanging on through things I would normally have been like, hey, I'm throwing in the towel. Things are just not working. I would have thrown in the towel a lot longer. But when you got a kid and it's your family and it's your future and you've committed to that person, I mean, those are high stakes. And it's hard to just let that go. It takes people sometimes years to recognize.
And like we said, mediation is part of the process.
Yeah.
Being able to work through all those emotions is the big, larger process. Right. But in terms of mediation, you have to give each party a reasonable time to express those thoughts.
Right.
So that they know that they're being heard. It provides some context
Sure.
to why they're asking for what they're asking.
Sure.
If you don't do that as a mediator, then the party is entitled to feel that you're a little disrespectful of them.
Mm-hmm.
We don't want that. You'll lose all your credibility.
Well, and sometimes people will show up to a mediation. You don't have to go with an attorney. You don't have to go with a friend. You could go completely by yourself if you're up to it.
Right.
And you could always say, hey, I'm not going to sign any agreement that we make today until my attorney's looked it over. That's a smart move too.
It can be, because honestly, sometimes the attorneys are the bigger part of the problem.
Right.
Sometimes the attorneys simply get in the way.
Right. And they're trying to, push it or too much.
Well, they grandstand for their client,
Sure.
and they're going to, go to bat for them. That's okay to a point.
Right.
But sometimes the attorneys do just kind of get in the way.
Sure. And so if you go, you could show up to one. And as we were talking about the mandatory part, you're not forced to go to mediation. It is mandatory that you try.
Yes.
If you showed up and said, I know it's not going to work, thank you, everybody, and went home, you could. But I think, like we were talking, at least give it a shot. Go there and give it a shot.
Most mediators that I know, including myself, charge a 2-hour minimum.
Sure.
So I say, you can
After
leave
2
now.
hours, yeah.
You can leave now, but you're going to
Still
pay me
gonna
for
cost
2
you 2
hours
hours.
anyway.
May
So
as well.
let's see what we can do.
Sure. And that's a good way to go, because, give it a shot. If things are just going horribly at, 1 hour and 52 minutes.
Well, I know that if I was paying somebody for 2 hours of their time, I'd want to try and get something out of it.
Absolutely.
If nothing else, I want to get information from the other side to help me prepare for my case.
Where you're going to go with it, sure. Well, I think we've asked some pretty good questions, and I think we've covered a lot of ground. Is there anything else you might want to add, or?
Don't be afraid of mediation. I think that you should embrace it.
Okay.
Make it work for you by being prepared in advance, by learning to stick to the issues that are relevant
Okay.
And be open-minded, because there's always another point of view that you may not have thought of.
Sure. And do you want to give any kind of contact information, or, I mean, people can already Google you. That's how I found you.
Oh, did
But,
they? Oh.
Yeah. Well, I mean, when I look up your number, I look up your name.
Okay. Well, my name is Clark Ward. Clark Ward 0071 at msn.com is my website.
Okay.
My phone number is area code 801-903-7444.
Okay. Perfect. Is that the email you use then? Or
Yeah,
is that your...
just down in one email. Yeah.
Okay.
Yeah. Oh, you
Perfect.
asked a question too before we conclude. How do I dress?
Yeah. Do you need to show up? I mean, is it one of those things where, because I mean, sometimes when employers are like, well, you got to wear a suit because then it puts you in the right mind frame. And I believe some of that. I mean, when you're dressed nice, you probably behave a little better.
Yes.
But if you show up and you're all sloppy, you're doing yourself a disservice, because you're not going to be taken as seriously when you show up.
That is true.
All
We're all
messy.
human.
Sure.
We're all human, and 90% of all communication is nonverbal.
Sure. So I would show up.
Be comfortable.
Yeah. Don't overdo it, but show up, dress nice.
But
yeah,
give the meeting the dignity that it deserves.
Sure. Don't show up in ragged shorts and your hair undone and just a mess, because then it shows you're not serious.
Well, you asked if I had some other maybe not so good experiences.
Sure.
I remember a mediation where the other attorney showed up in a Hawaiian shirt, shorts,
golf bag on his shoulder.
well, just about.
Yeah.
And I said, well, I called the meeting. I said, you're not taking this seriously, are you?
Sure. Wow.
And everybody else was dressed as they're going out to a nice dinner.
Sure.
And he comes in like he just washed off the beach or just came off a tractor.
Sure.
Okay.
And so you just said, I can't take you seriously the way you're dressed here. We got to call this meeting.
Yeah.
Let's re-adjourn, right?
Yeah.
Yeah.
So
I can see doing that. I mean, because, like you say, I mean, even if he didn't intend it to come across that way.
well, it sends a
That's how it's
message
gonna
to his
come across.
client too.
Yeah, then I'm not even taking you serious. Just give me money and I'll just do, just a half-baked job. And
Well, I'm just going to be a spectator, and I'm gonna dump this mess on the desk of the mediator and let him try and figure this out.
Sure.
Okay.
Sure, that's a crazy story.
That's
Hawaiian
not-
shirt guy, huh?
That's not being very helpful. Yeah.
Right.
It can be a team effort.
Sure.
But it's okay if the attorney's expecting me to deliver bad news. That's part of a mediator too.
Sure.
Because as an attorney, if you tell your client that what their position is on an issue is ridiculous or it's untenable, then your client feels like you, as an attorney, are not really advocating for them.
Like they're telling you that because they don't want to do the work.
Yeah.
Or you're psychologically trying to figure out what they're really saying.
So a lot
versus
of times,
taking it as truth.
a lot of times, I'm depending on the mediator to be objective and just say, look, this is not a winnable issue here.
Right.
This is not the hill that you want to die on.
I've seen that many times where, I mean, you'd think that people want to hire an attorney that's going to just tell them the ugly truth.
Yeah.
No matter how, don't sugarcoat it at all. Just tell me, am I hosed completely? Am I throwing good money away after bad? Yeah. And then you'd be surprised how many times, well, you probably wouldn't because you've seen it, but people get angry with that. It's almost like they want to be lied to. They want somebody to tell them some fantasy story. But your attorney's not doing you any good except stealing your money at that point. If that's what they do. Like, oh, yeah, we'll promise you the moon and the stars and you're going to get nothing. But I'll get in there and fight for you. Just keep handing me the money.
Yeah.
I would rather have a guy tell me straight. And even if I didn't believe him and I had to go see 3 or 4 more attorneys and maybe I throw my money away, I'm going to learn my lesson the hard way. And then eventually I'm going to realize, like we were talking about, I was told at the start of my divorce, you can't afford not to hire an attorney. Yeah. And I thought it was the biggest, gimmick to have me hire that person. And later I realized, man, they were just telling it straight. Now, they didn't tell me everything straight, but that was a total nugget of truth. Because had I known, man, my child support is going to be crazy. I'm going to lose more money in child support than if I threw $10,000 or $5,000 or whatever at this to solve it properly.
But you're the exact person that should be asked, if you knew then what you know now.
How would I do it?
Why would you do it?
Oh, I would probably do a lot of things differently. I would have represented myself as much as I could from the start, and then Got an attorney though for the times that I knew I was way out of my element. Some of the initial stuff, you don't always need an attorney, but you don't know, and so you're panicking, and so it feels good just to have somebody there. So now that I know that, I would probably be like, look, I'm not going to hire an attorney until I need one, but I'm gonna make sure they're paid.
Right.
We're gonna hit this. I'm literally just gonna pretty much give every waking second I have to it. If it's got to go to trial, I'd be way more prepared. And hopefully I'll never ever have to do that again. I am remarried, so
Good.
But yeah.
Well, see, that's important too. When you were going through this process, the idea of remarriage probably was the farthest thing.
Oh, I
from
didn't
your
think it was
mind.
ever going to happen. Yeah, and it took me about a good couple of years, and then I've been married successfully, remarried for a little over like 10, 11, been with the same person for like 12 years. Yeah, and so and she had kids, and she had two, I had one, and then we have two together. And
so see, it's the loss of the relationship is not the end of the world.
No, it feels like it at the time.
It feels like it at the time.
Yeah,
but that's where you need somebody that can be objective,
sure,
and experienced and knowledgeable.
And even if they're there just to say, look, A, you're not alone.
Yes.
But B, don't wallow in your own self-pity either. You got to avoid both of those traps. The first trap being, don't think, you're the only person that's ever had this happen to him. No. By large and by far, plenty of people are in your shoes. So
that's right.
You can feel comfortable in knowing that, but at the same time, there's a lot of stuff that you just have to let go of. It's like that. Right. It's like that analogy, or how they catch a monkey. You can't catch a monkey by laying a stupid trap, because they're smart. They'll figure it out. But they don't let go of things. They'll see a shiny object inside of a hollowed out hole in a tree. You heard this before?
I haven't heard that.
And a monkey will put their hand in there and get the shiny object. They want that shiny object so bad. Maybe it's their pride. Maybe it's the anger, the hurt that they had in their divorce. And I've used this analogy many times. They will not let go. You can just walk right up and catch them.
Yep.
They're so intent on getting that shiny object that they will not let go, and their hand won't come out of the hole. And so sometimes people use a coconut, or it's a tree, but that's how they catch monkeys.
Or a jar of candy.
Yeah, and they just will not let go of that prize to their own loss of freedom.
Yeah.
And I really think that's what happens to a ton of people in divorce. Because you're so caught up in it, you just can't see past it.
Well, and they think, I'm going to go to the trial, and then the judge is going to see things differently.
I'm going to get my justice. Yeah.
Probably not.
Yeah, maybe, but
maybe
a lot of money to get there, and you probably won't feel like it's worth it once you get there.
Yeah.
Yeah. So, well, I appreciate talking to you.
It's been my pleasure.
It's been good, and I'm really glad you came to meet with me and make this video, and I think a lot of people are going to learn some good things.
I hope so. And again, if they have any questions, they can call me.
Leave a comment, reach out to Clark.
Yep. 801-903-7444.
All right, well, thank you.
Thank you.